remedies with not too many sections left. And as we started last week and started to look at some of those issues, we're going to look now at interference with real property rights and what we do to try and protect those rights. And the cases, I think, are kind of interesting. Peters versus Archibald Boomer, which you may have seen before, Pate and Myers. We're also going to look at on Thursday Rule 13 on counterclaims. So you should take a look at that and look at your rule book. But what we're going to work on today is really this question about interference with real property rights, which means that you need to know about trespass and nuisance. So we'll talk a little more about those and see if we've got a handle on those concepts. What I can tell you from my experience is these are often litigated issues. I've done a number of different cases dealing with requests for injunctions, removal of offending pieces that both from the standpoint of whether it's the city or it's the country, you'd be amazed at how many different types of issues that surround people's homes that they're willing to litigate. I think the reason it happens is because it's by far most people's largest investment. They spend a lot of time at their houses, and they want to protect both their asset and their tranquility, and so they are very anxious to try and see that it's resolved. Sometimes it becomes a matter of spite when neighbors won't help each other out. Sometimes it simply becomes a matter that has to be resolved because it might be affecting the ability to sell or transfer the property. So I would bet I've been involved in over, or at least close to a couple dozen different types of nuisance and trespass and interference with property rights cases over the years. Unfortunately, they don't always, the solutions, since oftentimes if they can't come to a resolution on their own, are going to be an adjudicated decision, which means someone definitely loses, and that doesn't always set well with whoever it is that's lost. And now, in some cases, certainly if it's residential property, these people are still living next to each other going forward, and it's, to me, it would be a lousy, well, it is a lousy relationship. And how some of this happens, certainly, as we start to look at some of the encroachments and things like that, the trespasses and the like, it's actually, it happens very easily, I think, at times. And sometimes I think even more so going forward, people tend to accept less, fewer excuses going forward. But we need to define the trespass and the nuisance. And we talked about it before. So I asked Professor Martin to allow me to use and provide to you what he provides to his students during comparison. So we'll look at that, and then we can talk a little bit about the cases as well. This is what he gives out to comparison. I don't know whether you've seen this before, if you've had them for torts, but I think as a general matter, these are the definitions he's using during torts. And as we found the last time when we looked at it, there's a number of different approaches, meaning different definitions that people are using with respect to what a trespass is and what a nuisance is. His trespass to land is quite simple. The elements of the common tort claims: trespass to land, intent to entry on real estate in possession of another. Right? He says it requires an intent to enter onto the real estate in possession of another. Those are both the elements, and the only elements as he has it here. I'm going to read you Barbari's in a minute as well. But then I'm going to go to nuisance. And under private nuisance, 4 elements he has here are: defendant maintains a condition or carries on an activity. 2, that interferes with plaintiff's use or enjoyment of real estate, right, by non-trespassory means. So that's, and let me do the rest of it. 3, the harm suffered by plaintiff is substantial. 4, and unreasonable. Let me just ask you a question about the third part of this. The harm suffered by plaintiff is substantial. 4, and unreasonable. Down Plymouth, my brothers and I have a cottage. Alice, who lives next door, and they're all small land. There's lots of land down in coastal communities like that. They're like 5,000 square feet each. So houses are relatively close. Alice sits out in the yard and plays really loud, almost like opera music. I mean, sometimes it is opera music. Is that a nuisance?
Depends.
What do you mean depends?
What time of day does she do it? Is it substantial?
Like 2 to 6. No? What are you shaking your head? No?
I don't think so.
Why?
Because the harm has to be substantial and unreasonable.
Well,
but it could be disorderly conduct.
well, I guess this is what I'm wondering is, and it has to be both, because it almost does seem unreasonable. Why do you have to play it that loud? No? I mean, if it was that, heavy metal, I wouldn't want to, I mean, that would be potentially more offensive to me, right? But is that what that means, is unreasonable and substantial? And it does say and, right?
It's probably unreasonable. I don't know.
But not substantial.
Is it substantial? I mean...
So something could be unreasonable, but not substantial. But something that's substantial...
mean that it has to cause some... You have to be able to articulate some injury or damages that...
Well, it makes it difficult to sit in the yard and relax over a beer at the end of a beach day. No, that's not unreasonable. Go ahead.
I think it would just depend on the situation. I mean, what if the next door neighbor worked at night and was trying to sleep, or
But is that what it matters? So if instead of just sitting in the yard wanting to use my yard, instead I need to sleep then, and I'm telling you, but we really like Alice. So with Alice, it's not that big a deal. But I could imagine if the relationship was something other, or some other neighbor would say, someone else could say, no, that stuff's gonna go, right? Go ahead.
But I think, doesn't that matter then? If you're gonna pick and choose, it's fine with Alice, but not someone else. I think it has to be unreasonable if despite who it is, it's just a nuisance to you.
Well, is that true though? Because I mean, don't you put up with something from some of your neighbors that you wouldn't necessarily put up with others? No. No? Don't you think?
Yeah.
I mean,
Yeah.
I'm not going to cause trouble with them. They're okay. When the ball goes into the yard, they don't do stuff to the kids, so I'm going to cut them slack on the other end of it. No?
Well, that means it's not that bad that you can tolerate it.
So that means it's not that substantial.
Correct.
Continuous. Well, let me tell you. I mean, Alice actually doesn't live there anymore, but when Alice did, it was continuous. You could predict that if you came up from the beach in the afternoon, Alice, it was loud and she was listening to it, you could hear it throughout.
So this is true?
Yes, this is true. I've got a whole bunch of true ones if you want. I mean, no, seriously, I mean,
Yeah, but
reality, and I can give you cases where we've done, go ahead.
It doesn't become unreasonable until you request that she turns it down, perhaps, on days that you want to be up there and relax, and she says no, then maybe it becomes unreasonable.
But I guess, and we can come back to unreasonable, but substantial. What does that mean then? That means
Relative.
object, what, relative or subjective? I mean, is it to everyone?
It would be relative because let's say there's a biker bar across the street from the front of your house, and they have bands all the time in the afternoon, or a tiki bar on the beach, and they're always you know, so it's relative to the location that you're in, the type of neighborhood, I would think. The activities of all the other neighbors.
What are you saying, substantial is,
Yeah.
or unreasonable
Both,
is?
both, I guess.
Well, but I need some help to
I'm
find.
not really sure what, this, you know, the
Sub-
difference between substantial and unreasonable is. They're pretty similar, I would think.
You think? Because I could see a difference.
What is it?
Um,
I mean, I honestly, you know, to be substantial.
Well, because
it has to be
unreasonable, you don't have to play your music that loud to enjoy it. You just don't, right?
Right.
You could, you could play it inside your house, and then I wouldn't hear it as much. Or B, you could play it outside your house and sit in your yard, but you could turn it way down, way down.
Earphones.
Oh, you can wear earphones, correct. So what you're doing is unreasonable. Is it substantial though?
Yeah.
It is.
It's
4
unreasonable.
hours?
4 hours. What makes it substantial? The length of it, the loudness of it,
Well, I mean.
all of that?
Yeah.
How do you know, because I thought some of you were going, well, how do you know you're just not being a pain in the ass?
Who listens to?
Huh?
Who listens to their music blasting every single day for 4 hours?
She does.
That's a lot of that.
That's all she
A
does.
lot
than a
of people
few
don't
minutes.
have the time for that.
True. What about smells? She cooks. She doesn't listen to music, she cooks. But man, the stuff she cooks smells rotten. Cabbage cooking for hours.
Every day.
Huh?
Every day.
No, but it smells, right?
Yeah.
Bakeries. Near us, there we have what we're determined as a coffee roaster. I like the smell. It smells like sort of burnt toast in the morning. I like the smell. But I'm probably 2 miles away from it, and I have to pass it, and I like the smell of coffee anyway, so I enjoy it. But my guess is sooner or later that one's going to come up as well. Is that substantial? When I was little, we lived in Dorchester, and Walter Baker's chocolate was there. And I lived miles from Walter Baker's chocolate, and you could smell Walter Baker's chocolate a good distance away, and loved the smell. Still love the smell of chocolate. Is that a nuisance? I had a client come in. They bought next door to the grammar school because they were hopeful that their child would be able to go to the grammar school. And you know how nice that would be to just have to walk to school. Wouldn't that be lovely? Right? Not have to get on the bus and everything.
Recess.
Well, it's not just the recess. The buses park out there to take those other kids who need the bus home. And you know, when they park out there in the afternoon, they're running. And they've got exhaust and diesel smoke filling their house and grounds.
Now you're talking about a public nuisance rather than a private nuisance.
Well, it's a public to a bunch of you, but to me, it's also private because I'm bearing the brunt of this a lot worse than anyone else.
They came to the nuisance.
But does that make a difference? I'm gonna ask you that because I've got some cases here. But is that substantial? So it's 15 minutes a day, maybe a half hour a day. It's not Alice's music for 4 hours, but the smell of diesel fumes make me sick, actually. And Geneva says yes, so that's substantial.
Yeah.
By the way, we've had the same problem in Haverhill. The trains that dead end in Haverhill, especially in the wintertime, they leave them running most of the night because they're afraid they can't get the locomotive started in the morning. And now as Haverhill builds up with more residences in the city, the people, and in the Bradford section, people saying, I don't want them running because they're noisy. B, they're polluting the air that I have to breathe. And C, it is unhealthy here. So all of those are potential substantial and unreasonable. And unreasonable, what about the social utility of what they're doing? You need to have trains to take people to work in the morning, right? That's another one in North Andover. You go up Sutton Street, still early, so huh?
I live in the middle of it.
You live where? On Sutton Street?
Yeah, when I see a person on a bicycle.
Oh yeah? You're the one that flips me the bird and tries to run me over on the bike? So do you live near enough to the sewage treatment plant?
A little bit the other way out.
As you go up Sutton Street, it won't, not yet, but soon, you're gonna hit, there's a sewage treatment plant, and when the wind blows right, it's enough to make you gag. Is that a nuisance? Well, for a limited period of time, or unreasonable? Is that unreasonable? Because sewage smells, doesn't it? I mean,
But they should have a remedy. They should be able to find, it's offensive to many people.
in all our history, have we found a remedy to make stuff not smell? All right, doesn't stuff stink? Isn't that the expression? So, because you've got to figure. Let me hit the public nuisance, and I wasn't crazy about the definition he's got here, but I'll read it to you. Public nuisance, and this is for the private cause of action, and some of you made reference to that with the bus case I asked you about. 1, defendant maintains or carries on a public nuisance. And then 2, the second element simply is plaintiff's injury is different in kind from, not just greater in degree than the harm suffered by the public generally. So I wasn't crazy about the definition for public nuisance.
Can you repeat that second one?
Yeah, the public nuisance, as he has here, I'm going to give you Barbari's too, which I thought I thought was better actually. 1, defendant maintains or carries on a public nuisance, but you got to define public. 2, yeah, exactly. Plaintiff's injury is different in kind from, not just greater in degree than the harm suffered by the public generally. That's what he's got for public nuisance. Let me flip right to Barbari's for public nuisance because I liked it better, and this is the one I sort of remember. Barbary defines public nuisance is an act that unreasonably interferes with the health, safety, or property rights of the community. Public nuisance is an act that unreasonably interferes with the health, safety, or property rights of the community. And then add to that, recovery is available for public nuisance only if a private party has suffered some unique damage, not suffered by the public at large. So I think that's a good definition of public nuisance. Did one of you guys say you had another one?
I do.
What do you got?
Yeah, public nuisance is an unreasonable interference with the public's right to property. It includes conduct that interferes with public health, safety, peace, or convenience.
And peace, I think probably should be included in the Barbary one I gave you. It doesn't say it, but I think that's what they mean as well when they talk about health and safety. Go ahead.
And the unreasonableness may be evidenced by statute or by the nature of the act, including how long, how bad the effects of the activity may be.
Well, that's what you guys were suggesting with Alice's music, right? So do you have the public nuisance down? Public nuisance is an act that unreasonably interferes with health and safety. I'm going to add peace. Peace or property rights of the community. Recovery is available for public nuisance only if a private party has suffered some unique damage, not suffered by the public at large. They defined private nuisance, I think, was very similar. I'll give you that if you'd like. Private nuisance is a substantial, unreasonable interference with another private individual's use or enjoyment of property he actually possesses or to which he has a right of immediate possession. Let me just tell you what Barbary says about substantial interference, so that as you can start to think about it as we look at our cases. means that it must be offensive, inconvenient, or annoying to an average person in the community. It will not be characterized as substantial if it is merely the result of plaintiff's hypersensitivity or specialized use of his own property. Or annoying to an average person in the community.
And hypersensitive or,
Hypersensitivity or specialized use of his own property. You know, suppose I was doing a recording studio on my land, so while the music wasn't generally too loud, it was sufficiently loud that it affected my use. That's probably no good. But Alice's music was really loud. Would that though be offensive to the average person in the community? Loud music over a prolonged period of time.
Yeah.
In the afternoon.
depends on the.
Across the
community.
street from us there, when we first moved to Plymouth, they had a rooster. About that.
That would be so
Would it?
Is it making
Because-
noise?
Oh, about 5 a.m., but early, you'd hear the rooster crow. You used to hear the rooster crow.
Yeah.
So someone keeping a rooster in an area where, what are you looking at like that for?
Because I got a rooster that doesn't know when sunrise is down a couple of houses away from where I'm living right now. Like 2:30 in the morning. If yeah, I'm ready to go down and like.
You'd settle for 5:30?
5:30 would be great. Oh yeah, 2:30 in the morning. This rooster is going. That's.
So, by the way, farms, I mean, you've done that first year as well. Some of you did it first year. Farms are a historic
But it's zoned
source of
farm,
these types
yeah.
of problems, even where they're zoned for it.
Yeah.
Very, very common that we have significant issues relating to that. Unreasonable interference, by the way, just so that you can think about it in the context of these cases and some of the examples I gave you. To be characterized as unreasonable, the severity of the inflicted injury must outweigh the utility of the defendant's conduct. And you know what I mean, that's our sewage treatment plant example. That's the airport that, instead of being that small little airport, becomes a lot more industrialized and the like. It says, courts take into account that every person is entitled to use his own land in a reasonable way, considering the neighborhood, land values, and existence of any alternative courses of conduct open to the defendant. Interesting. And let me just, again, I'm not
Doesn't
trying
that
to...
make a good argument?
What?
But the alternative course of conduct, like for the buses, could they, turn them off while they're sitting there?
Well, they
You know?
should, right?
Right.
I mean, they should, on a whole bunch of reasons they should turn them off. The problem is the counter argument is they don't want to do that in the winter because they may not restart. And that's why they let them run. And again, if you're the bus driver and if you're the kids getting on the bus to go away somewhere, okay, that has a certain value to it. If you're living next to it, then what appeared to be a real plus, and it really did, it was kind of sad for these folks, because it became a horrible negative. They'd have the windows would have to all be closed throughout the day, because otherwise the house was close enough that it would fill with diesel fumes. I mean, I've got others, but let me just give you the trespass to land. Trespass to land, just to distinguish it from private nuisance. Trespass is an interference with the landowner's exclusive possession by a physical invasion of the land, where nuisance is an interference with use and enjoyment. And I think that's a really good way to distinguish it. When we plead these cases, though, by the way, oftentimes we're going to plead both counts. Because in a lot of these cases, when they're diesel fumes or paint cases or the chocolate smell, or the coffee smell, or the smell from the sewage treatment plant. All of them are issues that legitimately you're going to find case law support that it could affect both possession and use and enjoyment. And lastly, I'll give you the definition of trespass just so that you have something. And again, it goes back to what I distinguished for you. Trespass is an act of physical invasion of plaintiff's real property. And the intent that you were telling me about last week on the defendant's part is to bring about a physical invasion of plaintiff's property. And then you need to show causation. Let's see if they better define your intent for you. Not well enough, I don't think. Mistake doesn't matter. Intent to trespass is not required. Intent to enter on the land is sufficient. Intent to enter on the land is sufficient. What I'm thinking about there, though, is, and I'll ask you what you would have done with this case. When I was in Boston, I had these clients come in to see me, and they had moved. They had just bought a house, probably 4 houses away from where I grew up, and they lived on this street here. I lived on the street over here, but it wasn't that far away from streets. But in the middle of a city block was all these houses surrounded what's probably one of the largest auto body places you likely ever saw. And they did all the police vehicles and ambulance for the city of Boston. So it was a really huge auto body place. And they were there since I was little. These people bought it probably, by the time they bought it, the place must have probably been there 40 years. Maybe shortly after cars were started, they started fixing them at this place. And so they bought their house there, and then they moved in, and then they had 2 little kids, and then springtime came, the kids go out in the yard, and we smell paint. So they came in to see their lawyer. So I said, of course you smell paint. The place has been there since the world was flat. Well, we shouldn't have to smell paint. And paint shouldn't come into our yard. Which is fair. So would you take that case?
I would ask them if they smelled paint before they bought it.
We bought it, listen, it's like some of the situations we've had when we bought it in the winter. We saw it there. We saw it there. We saw it at auto body place. But if you're close enough to it, you're going to smell paint. And frankly, she's had health inspectors out. This you can prove the invasion of the paint into her property. And listen, and we can look at this and start to investigate and determine that modern day standards say that you shouldn't be smelling paint if there's scrubbers and the like in place and they're doing it in accordance with the requisite standards. Now, obviously, there'll be occasionally where things go wrong, but this was a very old auto body place, and it was large, and my guess is that everything wasn't always done according to code. But you also, as someone you already pointed out to me, you came to the nuisance. So, you taking the case? You're going to shut them down. Because that really is the only likely solution here, right?
No.
What do you mean no?
You just said that there are remedies available. They can do different things for smells, different kinds of.
Yeah, but the likelihood is once you get into it, the scrubbers and the like that are going to be required are cost prohibitive There's, you know, at the end of the day, you're still living next to an auto body place. And it's maybe virtually impossible to eliminate it completely. But that's not my worry. Your client says they don't want to smell this, they want the kids to enjoy the yard, even if it had been there all this mile before. Moving on.
If you can prove that there actually is an injury to these people, rather than just they don't like the smell.
Well, but when we say they don't like the smell, I mean, I don't like the smell because my guess is that not my guess, there must be some harm to it, right? If I can smell auto body paint in my house, in my bedroom, and when my kids are playing in the yard, that's more than just, I don't like the smell, it's that this has to be unhealthy, right?
Right, but it means that the other neighbors are also smelling it, so there is a case there.
Well, the other neighbors aren't complaining, and to your knowledge, go ahead.
Yeah, you really have to get those other neighbors to complain, because that's part of proving the substantial, interference. It's
Well,
the
that's
average-
what it is, I do need more, or?
If the whole rest, they could say, look, the whole rest of the community isn't complaining, the average member of the community doesn't consider this a nuisance.
My guess is the others may not be complaining because you would have been impossible to miss that you are buying, and my guess is your price in part reflected, that you are buying your home immediately next to what may be one of the largest auto body places I've ever seen.
They all work.
Well, some of them will work there, some of them may work there, and some people working are going to be out of business, right? And so that's what you have to start to think about. But your client says we're going to be done with this and it's time to move on. So, not for us to decide this whole thing about who came to the nuisance first, or will play out somewhere down the road.
You're asking us if we would take the case if they have a case. They have a case.
But I'm wondering whether you feel that this is an excessive use of your power as an attorney. No?
You may not win.
Huh?
You may not win.
Oh, but don't you think it's like, I think you have a good shot at winning.
Okay.
But I also, I'm wondering, it always struck me that it seemed a little unfair about it, though. Isn't there some level of unfairness to it, no?
Then you're setting yourself up not as an attorney, as a judge, and that's not.
True.
That's not what we're doing.
Not our job.
Right.
The judge will decide if we're right or not. We'll advance the case. Let it roll from there. So Fred's rooster has to be killed. That's just the way it goes. No, really, right? Well, and by the way, dogs fall into the same category. There's been cases where, you know, vicious dogs. I can guarantee you, the place where I drop the dogs off now, there's going to be a problem because a few years back there was no one living anywhere near the kennel, no one. And the last few times I've been there, I see these big houses over in Boxford now, and I dropped them off for Easter, and I'm telling you, I took a double check, big huge houses, and they must be, they're 50 yards away, and when you pull in sometimes, those dogs are going crazy. And if I'm living in one of these big old houses in Boxford, I'm not really interested in listening to yapping dogs for hours. That may well certainly take place. Now the other day I did notice they were quiet. I didn't quite understand why they were so quiet, but they were quieter this time, but they're not always. Maybe it was just fewer dogs there, because like the holidays, sooner or later that's going to be a problem.
I was going to bring that example. My friend bought basically a old farmhouse, which turned into a development behind it. And her business was dog watching, and they had like 30 dogs there every day, and they shut them. The town ended up shutting them down. Yeah, but it's no different than the pig farms that have been there for 100 years that get shut down.
Well, we've got that, which
In Andover, right? Wasn't
that
it?
way, right?
Yeah.
If you went out the back way, there's a pig farm across from, is that Blanchard's? No, it's not Blanchard's over there. Blanchard was the Dargunian, the case you guys did first year.
Right.
The pig farm is over here on, is that Chandler maybe? Anyway, if we went out the back way, There's a pig farm over there that has had significant problems with the town and the neighbors over the years, with the attempts to try and shut them down. Let's talk a little bit about Peters versus Archibald, which is the trespass case, equity jurisdiction trespass. And let's talk a little bit about registered land, because these issues come up as well. By the way, if I didn't make clear, a lot of times these issues don't come up until there's a transfer of the property, or an attempted transfer of the property. And then when the transfer comes, or it is attempted, sometimes there'll be not a survey of the property, but there'll be an attempt to make sure that things are where they're supposed to be. And what we call a windshield survey, where they drive by, they don't go out with instruments and take a look and hope that everything is where it's supposed to be. Sheds oftentimes are never where they're supposed to be, and hopefully they can be fixed. Driveways are often not where they're supposed to be either. In my experience, what happens there, especially in newer developments, is when the first house is built, if some of the builders hit stone, they just simply move it 15 feet, 10 feet, whatever, and then every other house in that development is off by 15 feet. And there are entire developments where all the driveways either start or end on someone else's land that sooner or later becomes a title problem and has to be fixed. This is a encroachment by the defendant's house on a relatively small lot down in Marshfield. And it's registered land, which has with it a certificate of title. What does that mean, that it's registered land? Because that in Massachusetts provides it with additional protections. What does that mean? Go ahead.
Likely there's like a court order or something.
There's like a court order?
There's likely a court order where they would have already figured out all of the measurements and then put it in its own registered land section versus reported land.
And then that comes with it a certificate of title. And so you can see the description of the property, and you can see all the liens and encumbrances there are with it. And the court, in essence, confirms the title to that real estate, and from there forward it becomes what's known as registered land. It is different from land recorded in the Registry of Deeds, because there could be encumbrances that you don't readily see or you haven't discovered. The quality of the title, at least, is considered to some extent more suspect because other claims can be alleged against it. But registered land gets significant protections in Mass, and one of them, as we're going to see in this case, is from claims of adverse possession and the like. So we've got a relatively small lots down in, again, the beach area, and again, they're very, very common in these coastal communities where the lots are small, the building is a little bit haphazard, and also people extend onto them until all of a sudden we got a problem and no one understood it was. Here there's an encroachment 465 feet, 15 feet 3 inches onto plaintiff's lot to a depth of 31 feet 4 inches. So the building extends 15 feet 3 inches for a depth of 31 feet, 465 total square feet. That's a trespass? Why?
Intentional invasion of somebody else's property.
Intentional invasion of someone else's property without permission. What makes it intentional? Just that it's there?
It was built on the other person's property without permission. I mean,
And even though I may not have known, because this is all very common, right? And by the way, fences, right? If you think of all of the things, fences this happens with, sheds, sometimes even buildings of this sort. I intended to build it, I did, it's there, and now, question is leave it there or pull it down. But we've got an encroachment of 465 square feet, which is a small condo. And then it says, and at some point, obviously, this is discovered. Judge found that it's expensive to remove the encroaching property, portion of the Archibald's building. He says that there's no estoppel or laches on the part of the plaintiffs in seeking to have the encroachment removed. What's that mean? No estoppel or laches? Take one or the other. Go ahead.
Well, with laches, they didn't sit on their rights for too long, so they're able to bring the suit.
Right, that they, laches is a delay in asserting your rights which causes prejudice to the other side. That they did not just simply delay in bringing this such that it caused him prejudice. And the estoppel?
They haven't brought a claim before.
Well, that's more collateral estoppel. What do you think this estoppel would be?
There's nothing precluding them from making the claim.
Why? So, because it's estoppel in this case.
There's no permission, there's no adverse possession.
Yeah, this is really sort of the change in position.
No easement or anything like that.
Right, change in position. I relied on it, it caused it to my detriment. I'll give you a good example of that. Up in Salisbury, client wants to put elaborate stonework in on the side of the property and a nice stairway up and over to the bluff. Neighbor comes out and says, "What are you doing?" He says, "Well, I'm going to put some really nice and very expensive stonework in." He says, "Well, you don't know where the line is." And he says, "No, I think I do." He says, "Well, I'll show you where the line is." And the neighbor goes out and puts all the stakes in all the way down the line between the two homes. So he builds the stone, has the stone wall built, a fair price, a lot of money. Either midway through it or close to the end, the neighbor comes out and says, "I don't think that's right." He says, "Well, I had it built right where you put the stakes in the line." He said, "No, I think that's wrong." He said, "I'm going to have it surveyed." He has it surveyed. He's off by 6 to 8 inches, and the stones now protrude 6 to 8 inches onto the other land. And at this point now, we're looking at a job of somewhere around $25,000 to $35,000 to tear up the stonework that's been installed where you said to install it. And of course, the discussions break down and the lawyers get involved. Well, I relied on where you said the line was to my detriment. It's not fair now for you to change that position, and the argument is that should constitute an estoppel. Yeah, you know, that might be even an example where you could argue laches as well, because you saw me building it, you delayed doing anything about it. Actually, in this case, you did something affirmative, but that you delayed asserting your rights earlier, and the prejudice is I've spent $35 grand to put it in the way it's supposed to be. That actually could be an example of both estoppel and laches. And again, it's important when we think about these equitable remedies that the court is really trying to look at what's fair under the circumstances, what would be just. And so all of the parties' actions become relevant to the inquiry.
Could I ask
Yeah, go ahead.
In this Peters case, the original builders built in 1946.
Yep.
So you get a 20-year period.
Yep.
Right? Perhaps.
Yep.
Depending on what month the house was complete. Or
Yep.
once it encroached on the land, doesn't that start the tolling of the statutory period for adverse possession?
Yep. Yeah. By the way, I was going to ask.
So could the new owners assert the adverse possession?
You can tack on to the earlier landowner's claim. But let me ask that, what is adverse possession?
Openly,
You're just not going to give me the
Continuous.
words. Openly what?
using the property of another
Openly using the property of another
for a consecutive period of time.
for a consecutive
For a
period of how
For a
long?
statutory
Or
period.
statute.
What's the statutory period in Mass? Yes.
20.
20 years.
20 years. So openly using the property of another for 20 years.
Adverse, exclusive,
Exclusively?
entirely.
Openly and exclusively?
Notorious.
And with disregard for
You guys really need to know this stuff better than this. What's it?
Oh, I know.
So tell me what the elements are, and then you might be able to put it into an English sentence. Open, notorious, hostile, exclusive, and you guys had continuous, right? Actual. What the hell's actual? Meaning what? No, I know they add actual, but how is open, notorious, hostile, exclusive?
Like an owner,
Huh?
using the land like an owner.
But isn't that open? See, that's the part I don't understand. I know you guys had actual, and I know it needs to be open, notorious, hostile, continuous, and exclusive, and actual. But see, when we were taught 4, you guys have expanded it to 6 by changing a couple of them and making them broader. But open, notorious, hostile, exclusive, you guys say, well, actual and open, notorious, hostile, continuous is what we use. You guys add actual and exclusive, which to me is part of open. No?
Adverse has to be in there too. Adverse. to
Well, hostile. Hostile is adverse, right?
And statutory period.
That's continuous.
That's continuous. See, you guys make too many elements. No, it's harder to. It's easier to remember fewer than more.
We are taught the acronym OCEANS, so that's the acronym.
Oceans. So what's the S? Oh, the statutory period.
Statutory period.
That's fine. That's okay. So tell me open, C, continuous, exclusive,
Actual and hostile.
actual and
Yeah, there's
hostile,
2 ways. Yeah.
Notorious and statutory period.
notorious and statutory period. Okay. So Fred says 1946. And when does this happen?
66.
66.
July of 66.
20 years, right? So this would be adverse possession, which, by the way, a lot of these cases become that as well.
So that could be their counterclaim.
And the same thing with driveways. Well, let's decide about it. Do you think they make the elements for adverse possession? Forget everything else. You think they make the elements for adverse possession? Which, by the way, I've had 2 adverse possession cases that I've had to do. One when I did them here in Andover, and I had to go before the town to something. What they said is, I haven't heard adverse possession since I was in law school. And B, it still happens, and you still end up having to potentially try the cases to resolve them. And a lot of times they're resolved as, well, at least in part, in land court and the like. So they would satisfy the elements of adverse possession. Except Geneva says it's registered, right?
Well, what's up now?
By the way, we'll talk about that. If it's, so by adverse possession, you actually acquire the ownership of the piece of land that you have adverse possessed for that period of time, right? That's what adverse possession does, right?
You acquire title.
You acquire title to that portion of the land.
Or an easement to.
Or an easement, depending on the
if
use.
it's a path.
But this wouldn't be an easement here,
No, this
right?
is
This would
title.
be, you would acquire the title because you have satisfied the elements.
So the title would have the obstructing means and bounds in it that's obstructing the other property?
You would.
So that would be in the title?
You would have, and this is why the land court process would probably be the best to do it. They would confirm what the new meets and bounds descriptions are to your property with this 465 feet as part of your title now, not the other side. That's why it's probably easiest to try them in the land court. You're not required to. You could try it in Superior Court in Massachusetts as well. But land court will, when you are done then, you will have a good, clean title to it, and also they are used to hearing disputes of such sort. So it's not like, oh, I haven't done this since I've been heard about this since I was in law school. It's actually not that uncommon. So at any rate, they could satisfy adverse possession. Geneva, why can't they? Why is adverse possession not a potential defense to the plaintiff's claim here?
Because under
registered land, it would have been, a court order, so they're already specified exactly what it is, and you can't adversely possess on something that the court has ordered.
In Massachusetts, we have a very firm rule, and we'll talk about Judge Toro's dissent and the like, but in Massachusetts, we have a very firm rule that you cannot have adverse possession against registered land, right? If this was any other type of land in Massachusetts, it would be problematic for the plaintiff, but here, Massachusetts, you can't have adverse possession claims asserted against registered land. The law, it says here under Arabic 1, in Massachusetts, a landowner is ordinarily entitled to mandatory equitable relief to compel removal of a structure significantly encroaching on his land, even though the encroachment was unintentional or negligent, and the cost of removal is substantial in comparison to any injury suffered by the owner of the lot upon which the encroachment has taken place, and it gives them this Garagosian case. Annie. And then, if we go later on in the decision, it talks about only if we're looking at potentially encroachments of a de minimis nature. And de minimis, what we're looking at is inches, not feet. What might be considered a de minimis encroachment if you look at, I think it's footnote 3, but where the encroachment is small or slight and thus within the de minimis principle. Downspouts, gutters, fire escapes potentially. But we're talking about, in all likelihood, inches, not feet. What do you think of that rule? Or do you just like it because it's clean? Even where the encroachment is made innocently and the cost to remove it is significant compared to the harm. Out it still goes? Go ahead.
They just did that in Marblehead. Did you read about that?
Yes, I read that one.
Yeah, a house that they took, the whole house is gone. And isn't that very similar to this?
Yes, yes, that was a building permit issue that probably shouldn't have been, well, clearly shouldn't have been done without the full permit at that point until the appeals process had run. But yeah, it's very similar. Because we make the argument about economic waste, right? I mean, and by the way, some of that is, those are decisions made at the time. No, build it, who's gonna make us tear it down? Because some of these issues do come up during the course of the renovations and the like. And one theory has been in the past, who's gonna tell you to tear it down? But your example in Marblehead is a very good example of it. There's an oceanfront home that the guy built, at least the Globe story talked about with his life savings, and they made him tear it completely down. And there are more and more examples like that. We've got a similar one going on in Andover now with a pool in the Cabana house that exceeds. The neighbors are complaining because it's problematic. What did you say? That's your uncle?
The neighbor of the pool, or the owner of the
His
pool?
pool house is like completely too big, and he built it over the town like limits.
And it sounds like it's gonna be one of these messy resolutions. Well, let me ask you about that. What do you think of this rule? Because what if it's the bathroom? What if it's the kitchen? Again, in some of these coastal communities, if I've got a 5,000 square foot lot, there is no place else to put the bathroom and meet modern standards. There's no place else to put my septic system and meet Title V. By the way, I could give you that story. Down in Plymouth, at one point when they were built, as it turns out, the septic is on the other neighbor's land. So it's not anything anyone could have discovered beforehand, but his driveway sank, so what the hell's going on? Then the toilets won't flush. Didn't take too long to put two and two together. The septic system collapsed. The septic system was on the neighbor's land, and at one point, there were 3 houses feeding into it. So that's a trespass. And so, could I acquire that by adverse possession? Sort of the easement that you were talking about? I could?
Well, no, because it wasn't exclusive.
Yeah.
Well, not open either, is it?
Right.
Right, simply applying your elements, how would you even know it was there?
Don't you know your septic plans?
We know, none of the three of us did know that it was there. And the same thing with foundations and footings. Sometimes when we're in tight quarters, these are the types of things that happen. And so that can't be adverse possession. It is a trespass because it's a physical invasion, and you better be able to remedy it or you're out, right?
But the problem is you may not be able to remedy it because there's no other place to put your septic system.
And especially with the more stringent modern standards, what we're talking about here is at some point is these may not be salvageable.
So now it makes your home have no value.
And that's what I'm asking.
Yeah.
That's the way it goes. So we'll tear out the bed.
Under the Title V, does everybody have to have their own septic system?
I think now you do.
So then all of those 3 people would have to go about getting their own septic system and fixing the one that was ruined.
That's correct. That's likely. And for the one where it's located, it's not going to be a problem because he's got like a double lot. That's why I assume it went there. But for the other 2, the lots are tight, and to try and put in a modern septic that will comply Title V with the state regulations is going to be very tight. These types of issues come up frequently in the coastal communities. So let me just ask you, do you like the rule of law? Or, yeah, I like something relatively fixed like this. Too much gray when we're studying law period. This says, A, I like the rule, you cannot have adverse possession against registered land, and B, that in Massachusetts, an offending structure will ordinarily be, the court will ordinarily require removal of the offending structure, in essence, because a person's home is their castle, and they have the ability to protect their land, and the court will enforce sort of those ancient rights.
I don't like it.
I like it.
Okay. You don't like it because it doesn't give them, the court, enough discretion? I mean, what would you have done something differently here?
I wish that there was a way that they could offer them compensation in lieu of tearing, in lieu of tearing down part of the structure. We'll offer you money, whatever it's worth.
Well, but my guess is, and this is what you have to remember with a lot of these, the negotiations have long since broken down.
Right.
And so that's why they're hard decisions, because they couldn't solve it on their own. You tried to work out various resolutions, and it still didn't work, and now you're leaving it in someone else's hands, and as you see what the law is, it can be harsh. Litigated one in Braintree where the driveway had to be torn up. The driveway to get to the lot, the driveway started here on my land. And that was really, looked like the only access to that garage. And they hated each other by the time the case went to trial. And the court ordered, as you see from the case, this is what they're likely to do, they ordered the offending encroachment removed, which is the driveway. And if you went out by it, you'd go by the street, you would see this huge gaping hole where the driveway was, and it's like a 10-foot up in the air to get to the garage, and you can't get to the garage now. And it was clear before long that this is what the court was going to do, and your client, my client, wanted it removed, and he didn't want to hear anything other than that. And this was your client who was legally right. Seemed like I mean, as you pointed out to me, it's not my decision to decide what should happen. I have to represent him. And legally he was right. I don't know how you could live in a house like that then with someone next door who would probably run you over with their car if they saw you. But that's the situation I ended up, that's what I left behind is, okay, we won. They stayed, you know, my guy stayed there, I don't know for how long, but he stayed there, he got what he wanted, and my guess is his neighbor was, well, the times I saw him in court, was fit to be tied, but at the end of the day, the court really had no choice because of the lack of discretion. You like something fixed, right? And then, so why not some black and white? You know, because that's what I was going to ask you about Toro's dissent. He said, oh, come on, there must be something we can do here. It's the destruction of the land. There's some economic waste. Jeekers, can't we all just get along, right? No, you don't.
I just feel like, I mean, especially in the examples that you gave about the driveway, and I mean, people that are building additions, I feel like before you make any of those moves, you should know where your boundaries are. You bought that piece of property, and the person, your neighbor, bought their piece of property, and you should know your boundaries. And before you make any, or you spend money on such a significant expense, like, you better make sure nobody's gonna make you tear it down.
But you know they don't always. I mean, just as a practical matter, and you're absolutely right. But I can tell you why they don't. Well, you really should get a survey of your property, make sure everything is where it's supposed to be. How much is that going to cost me? Well, it'll be anywhere between $1 and $2 grand. Huh?
A lot less than tearing it down.
Well, and that's probably the better answer, is a lot less than later on if there are problems with it. But a lot of towns don't require the instrument survey either, and so people save money on that end, and that's where the problems come in then. And especially like when people put in pools and a lot of shrubbery, it probably would be certainly a better investment at the outset than to have to deal with it at the back end, because the case talks about anything other than de minimis is going to have to go. And so we can argue about de minimis encroachments, but they're talking about here de minimis encroachments in inches, not 15 feet by 31 feet, which, by the way, that is a pretty significant invasion. I've seen porch steps, porches, so we're talking maybe total square footage of what, 15 or 20? But people still, if it's there, they don't want it. I had a deal go south in Quincy. The driveway had been used for 50 years. There was no doubt, and everyone got along. Everyone thought, that's his driveway, this is mine. This is the way they had lived forever. And they were selling the property, and it came up. I called the neighbor. I said, you know, can I deal with can I tell you what happened, or can I deal with an attorney? Because I figured I could convince an attorney that this is a relatively easy swap that we could agree on. The problem is the land's registered. And if she's not going to consent to some easement, an easement, which isn't going to affect her rights really at all, other than to allow to take place what had taken place for 50 years. And she says to me, no, someone told me one time an easement's a bad thing, I won't give it to you. And I said, do you have a lawyer? Can I talk to your lawyer? Because we can work this out. The whole deal was going to fall apart. It did fall apart, simply because this buyer was going to take a walk, and now we're going to. The fact is, Lincourt's not going to fix this either, as well. But she had it in her head that she wasn't ever going to do this because someone said it's a bad thing, and maybe it is, maybe it isn't. And the other one time is it was clear that adverse possession would solve this problem, but that's going to take 2 years to litigate as well. And I got a deal going south right now that's not going to be salvageable 2 years from now. So we can both spend, and you're going to end up spending a fortune to resolve what clearly the court is likely to do, since it's not registered land. Wouldn't hear of it either. And so litigation is required under those circumstances where if people wanted to be reasonable, it didn't have to be that way. But these types of issues come up a lot. Go ahead.
What did the solution look like? I mean, would you have bought that strip from her, or bought the easement?
Just authorize an easement to use it. And in some cases, I don't know whether there was cross easements or whatever. Listen, if you went down my street where I live, and I know that the neighbors don't understand this, because they look at the cul-de-sac, and the houses all look like they lay out like this, okay? They don't, they all lay out like this, because I've seen the plans and I know the builder. They're all cutting each other's grass in front. No ifs, ands, or buts about it. If you looked at the entire planned development, instead of laying like this, they lay like this. So most of the houses are right. Most of the driveways, most are right. Not all are right, and certainly the front yards that they're cutting are absolutely not their yards. And that was built in '96, most of it. So 2006 are there, no, not '96 to 2026, right? No, 96, 16, right? 2016, all of these or thereabouts, all of these adverse possession claims come ripe, and there will be ample claims because the lot lines are not anywhere near where they all think they are. I made sure that mine are exactly where they're supposed to be, but I can tell you the whole first half of the development, they're all off. It's the same thing I saw in Braintree, is, you know, we moved it a little bit and then everyone else just moved by the same proportion, and a number of years later that ends up being a lot of pieces of litigation when people decide they want to keep what they thought was the status quo. So it's the nature of these types of things. And they're interesting pieces of litigation. The problem is they oftentimes leave some pretty bad feelings in the wake. Let's take a look at Boomer versus Atlantic Cement. You know, it used to be that Boomer versus Atlantic Cement is a pretty classic case that we read in torts. You guys, any of you read it? Did you read Boomer?
Yeah, we read it.
Right. And Boomer asked you to start to think about the utility of the product or of the company versus the nuisance and the problem it brings. And again, you know, when you think about your cement plants, your waste treatment facilities, your quarries, you know, if you look at Boston Sand and Gravel right down just this side of North Station, if you were living near that at the time when all the trucks are coming in and out and all the dust and everything else that's created from it, you wouldn't be that crazy about it, but we need cement to build cities. We need these trucks to move the equipment around, and so that stuff's got to go somewhere. Do any of you like Manchester Airport? No? I like Manchester Airport. You can get there in about 30 minutes. You like it?
I fly out of there all the
Yeah. Yeah. Parking is cheaper, and it's
They just
not
changed
free.
everything.
Huh?
They just changed everything.
I know.
Yeah.
I was there. I used it about a month ago. I was surprised. But very, very nice. But if you look at what happened to that neighborhood as Manchester expanded and became much more than some little sleepy airport, my guess is the neighbors would find there's a fair amount of nuisance and traffic with it and everything else. So let's just quickly take a look at this. But here we've got an investment in the plant of a sizable amount. But if we're living near something like this, it is a nuisance, isn't it? Does it interfere with your use and enjoyment of the property? They're saying there's dirt, smoke, vibration emanating from the defendant's plant. And again, I think this would be pretty easy to not want to live next to. But my guess is Freddie's Farm, a lot of people don't want to live next to either. The farm that I used in the first year, I knew when I first met those people, because the farmers were friends of mine. I knew when I first met the people who had moved into these big, beautiful homes, this wasn't going to last, because there are farm smells that those of us from the city aren't used to. And it may be cute at first, but over prolonged hot summer, it's not so hot. My brother lived originally near the chicken farms up in Maine, and you could be miles and miles away, and when the wind blew bad, it was enough to make you puke. tell me about the cement plant, because the defendant doesn't want to go anywhere, but obviously the cement plant, there's dirt, there's smoke, there's vibration, and a nuisance was found. And to some extent, obviously, it does damage the nearby properties, and it does substantially. And so therefore, they would like an injunction against that. And this says the rule in New York has been that such a nuisance will be enjoined. And again, this is what I think where the fairness part of it comes into play, although there's a marked disparity in the economic consequences between the effect of the injunction and the effect of the nuisance. So tell me, actually, I want you to, if you haven't taken a careful look at the case, to take a careful look, because Boomer really does lay out the various options when we're looking at nuisance cases. Because Boomer and Del Webb both reference these situations where you can come to the nuisance, and just because you came to it doesn't mean you're foreclosed from objecting to it. What it might mean, and we'll talk a little more about the case when we meet next time, what it might mean is the type of remedy you're going to get could be different, or that you may even need to contribute to some extent to helping resolve it financially. So I want you to look at that case carefully, and I want you to think about it, and think about it in relationship to some of the situations you may be aware of, and some of the things that I told you about. You know, I've got the coffee roasters near me. I like the smell, but my guess is it's offensive to others. And we also have a couple of trash burning facilities near us, and the concern there is not just the smell of the smoke, but the harmful potential pollutants that come from those types of facilities as well, which is a frequently litigated issue now. So think about these, because I'd like to talk a little more in depth about how you'd remedy these, and to what extent you think that you would be able to have something to do. I also like the last two cases in the sequence, so look carefully at them so that we can talk about them. And we'll meet next time.